Okay, thank you everyone who's joined us this morning. Um, it's great to see so many people here bright and early on a Saturday morning. Uh, uh, Throughout this webinar, we're going to go through some questions that we prepared in advance, and then afterwards we're going to have a Q&A feature, or a Q&A session. So feel free to use the Q&A feature in Zoom to pose your questions. We'll try to get to as many of them as possible. Don't wait to the end to get your questions in. Go ahead and put them in right now. We'll ignore them for now, but we'll get to them in our Q&A session kind of after our prepared presentation. This session will be recorded, so don't worry if you miss anything. It's going to be posted on LandlordBC's YouTube channel, and we'll share it, of course, also with VISOA as well to have it go out in the newsletter. This is our second in our series. The third one is going to be held on January 20th, and that's a landlord's guide to communicating with strata councils. If you're on the LandlordBC or the VISOA email list, you'll be notified when registration opens. If you're not, then make sure that you do get on those mailing lists, and also watch for announcements on Facebook and X or Twitter. I'm not used to the new name yet. I think it's just Twitter. So again, welcome everyone and good morning to our webinar on Strata Council's Guide to Rentals. My name is Hunter Boucher, and I'm Vice President of Operations at LandlordBC. I have more than 15 years of experience in the rental housing industry and focus primarily on legislative issues and best practices. My co-host today, I'm so happy to be partnering again with, is Wendy Wall, the president of the Vancouver Island Strata Owners Association, VISOA. VISOA provides education, support, and advocacy for BC strata owners and strata corporations, such as condominiums, townhomes, bare land, and commercial stratas. VISOA and LandlordBC have teamed up to present a series of webinars to help strata owners, landlords, and councils navigate the complexities of rentals in strata buildings. Today, I'm going to be asking Wendy some questions so we can all learn the fundamental knowledge that all Strata Council members need to be aware of. Then we'll have a Q&A at the end. Please go ahead, type your questions in the Q&A box, not the chat. We don't have that open. And we'll get to those in the Q&A session. Like I said, don't wait to get those questions in. We won't look at them right now, but we'll get to them in the Q&A. So you know, if you think of something, put it down right away so you don't forget. So moving on to our session, Wendy, can you give us an overview of what we'll be covering today?
Yeah, you bet. I'm just going to first mention that I'm joining the webinar today from the unceded ancestral lands of the Lekwungen-speaking peoples, known today as the Esquimalt and Songhees Nations. And VISOA, Vancouver Island Strata Owners Association, honors the many territorial keepers of the lands and waters where we live and work. So today, yes, we're going to be talking about what does the Strata Property Act say about rentals, what paperwork a council has to keep, enforcement of bylaws and rules, which is always something we get questions about, when can a strata corporation evict a tenant, and also tenants, you know, what are their rights, what are their obligations?
Fantastic. Well, thank you. So let's just get right into the questions. What does the Strata Property Act say about rentals?
Yeah, it's interesting because the word rental isn't defined in the Act. The Strata Property Act, like any piece of legislation, has a great big long list of definitions. And sometimes the definitions in the Strata Property Act don't align with other legislation like the Residential Tenancy Act. So just a couple of boring points here, but important ones, is the Strata Property Act defines a landlord. It means an owner who rents a strata lot to a tenant, or a tenant who rents a strata lot to a subtenant. And then it has a definition for tenant, which means a person who rents all or part of a strata lot. And what's interesting is the Strata Property Act does not have a definition for what the word rent means, and yet the word rent is used about a dozen times throughout our legislation. And it also doesn't have a definition for the word tenancy, and yet tenancy shows up half a dozen times in the Act. So that's just something that's important to know, because it's a little bit different than the Residential Tenancy Act. And one of the interpretations there that's different is under the Strata Property Act, because it says all or part of a strata lot, a tenant, a roommate is a tenant under the Strata Property Act, and that definitely doesn't align with the Residential Tenancy Act. But the most important part of the Strata Property Act that you need to take away today is that previously we were allowed to have bylaws that restricted rentals, but since last November, since November 24th, 2022, essentially strata owners can rent out their strata lots. They don't need permission from the council. They can just do it. There's some really rare situations where the builder might have entered into a covenant about rentals with the local municipality. And in that case, that agreement was between the developer and the municipality, but it does, apply to the strata owners. But that's pretty rare. So generally speaking, everybody can rent their strata lot. And where this comes into the Act, if you want to look up the exact wording, it's under Section 141. And here's what it says. The Strata Corporation cannot screen the tenants, can't establish screening criteria, can't require the approval of tenants, like council can't say, we want to screen, we want to approve. Can't do that. You can't require the landlord to put certain terms into the tenancy agreement. And you can't otherwise restrict the rental. So a couple of examples of that. Some stratas have tried to do extra fees, extra deposits. There's a strata I know who doubled their strata fees for the landlords of, the owners of strata lots that have tenants. It's like, no, you can't do that. You can't charge them an extra administration fee or a management fee. Another thing I've seen is a strata where they said, oh, there's a move-in fee at our strata, and it's $100 for owners, but it's $2,000 for tenants. You can't do that. That's definitely, that's the most extreme example I've seen, Hunter, but it's just a really good, example of no, whatever your rule or bylaw is, it has to apply equally to the owners and to the tenants. That's the basic rule I use, is if it's some sort of requirement, then that means it is a restriction. I hope that makes sense.
I think that does make sense. Yeah, the Residential Tenancy Act has similar types of statutes in it, where treating something differently can act as a restriction. So I think that certainly makes sense. Thank you for that very thorough answer. So we're talking mostly in our last webinar and in this series in general about residential tenancies within stratas, but are bylaws permitted to ban short-term rentals?
Yes, absolutely, because short-term accommodations are not actually rentals. They're we call it a license for occupy. So strata bylaws can ban or restrict the use of strata lots for short-term accommodations because they're not tenancies. And one thing that's quite different in the Act is that the fines can be up to $1,000. But you have to have the bylaw. It has to be properly written to allow the strata to not only ban the short-term rentals, but also to be able to fine that high. You can't just fine unless you have a bylaw that says you can fine that high. And what I find really helpful to councils is if you look in Regulation 7.1, it actually gives you the words to help you describe what is a short-term accommodation, because it says that it's remuneration for a vacation, travel, or temporary accommodation. So it does give a bit of those words give a bit of guidance.
Yeah, and that's quite in line with the Residential Tenancy Act as well. It talks in the Residential Tenancy Act about what the Act doesn't apply to, and very clearly says it does not cover travel vacation accommodation. So yeah, that's great to see that the kind of wording around that is consistent. So paperwork is, I think, this industry's best friend. If there isn't a form for it, there probably should be. There's always forms for something, it seems. What paperwork does council have to keep and manage in relation to rentals?
There's two main ones. One is what we call the owner's list. Under section 35 of the Act, it lists all of the bits of information that you have to have in that list. So for example, for owners, it's the number of their strata lot, their mailing address if it's different. Do they have a parking stall? Do they have a storage locker? Things like that. But if you look at section 35, it also says you have to keep the names of the tenants and any assignment of voting rights, which we're coming to later. But that's, definitely, you must keep that in the list. And the other thing is a form. Hunter was mentioning forms. In the Strata Property Regulation, there's actually a lot of prescribed forms, and there's about 27. So they all have nicknames. Form A, Form B, Form C, but those are really just nicknames. So the Form K is the one that you're interested in here. And what the Act says is that before a landlord rents all or part of the strata lot, they have to give the tenant a copy of the bylaws and rules, and then they have to give them this form. It's called a Notice of Tenant's Responsibilities, but everybody calls it a Form K. And within 2 weeks of renting that, the landlord has to give the Strata Corporation that Form K signed by the tenant. And even if the landlord doesn't do that, if they forget to get the tenant to sign it, or they forget to give a copy to the strata, the tenant is still bound by those bylaws and rules, which we'll talk about.
Yeah, definitely. Well, on that topic, I mean, how do and can council enforce bylaws and rules against tenants?
Yeah, absolutely. And this, like I said earlier, is probably the most common question we get from councils. But yes, in fact, the council has a duty to enforce. And sometimes people miss this part of the Act where it says that the council has to exercise the powers and perform the duties of the strata, but that includes enforcement of bylaws and rules. So the first thing I mentioned when you were talking about enforcing bylaws and rules is establish who allegedly broke the bylaw rule. So for example, if the landlord or the owner of the strata lot is using their strata lot for short-term accommodations, they have allegedly broken that bylaw. So you enforce against the owner of the lot. But if there's a true tenancy and the tenant is allegedly making too much noise, or they have too many pets, or they're in a non-smoking building and they're building, then you're enforcing against the tenant, not the owner of the strata lot. So it's like who actually has broken that bylaw rule. But then other than that, the enforcement process is the exact same, whether it's an owner or tenant. There's just a couple of extra steps if it's a tenant. And basically what that means is after council has received a complaint and they've looked through it and maybe done a bit of investigation, they have to notify the person who allegedly broke this bylaw. It's quite a fair, the whole process is meant to be a chance to let the person know there's a problem and give them a chance to tell their side of the story, right? This is just a procedural fairness thing. But when you're notifying the tenant that, you made too much noise on Friday, November 17th, you have to give a copy of that letter to the landlord. So you're not saying that the landlord broke the bylaw, you're just giving them a copy of the letter you gave the tenant. And that's something that happens throughout the process. Every time there's a letter or notice that goes to the tenant, you have to also give a copy to the landlord. And then the fines are a little bit confusing for people. If you get to the point where council gets to the meeting and they review the answer that they got back from the tenant, if one came in, then when they make a decision, if they do decide to fine, you are, and this is where the mistake comes in, you're fining the tenant and you're notifying the tenant and the owner of the fine. the council doesn't have an account for the tenant. So you're posting the fine to the landlord's account, but the letter says who is being fined. So anybody can pay that amount. But I'll get into that maybe later with a few more details. But basically, that's the process, and you always have to inform the landlord.
Yeah, and I think that, you know, we can definitely talk about collection and such as we go on. Fines are obviously you know, useful deterrent. You know, and as you say, you know, the whole point of the system is to try to not get to that point. For more serious situations, is it possible that if a tenant were to break a bylaw, can their tenancy be ended by the landlord, by the Strata Corporation?
Yeah, both. There's part in the Strata Property Act that's called eviction by landlord, and then right after it, there's part called eviction by Strata Corporation. And that actually hasn't been employed, you know, all these decades, because the residential tenancy branch didn't, but I guess they weren't comfortable with this part of the Strata Property Act giving that kind of power to a strata corporation. But last fall, as Hunter knows, the Residential Tenancy Act, they changed one of their internal policies, policy guideline 27, to recognize that part of the Strata Property Act and say, yeah, okay, we understand that a strata corporation has this power under certain situations. So basically, the important part of this part of the act is it says, like, it can't just be for someone having purple curtains. It says it has to be a repeated and continuing contravention of a reasonable and significant bylaw or rule that the tenant of that strata lot has. And it's not just, you know, a significant bylaw or rule, but it's something that seriously interferes with another person's use and enjoyment of either their strata lot or the common property. In this event, the Strata Corporation has the power to do this. Now, this is definitely a last resort, right? We're hoping that you've gone through the bylaw enforcement process and that there's been some improvement. You're hoping that these copies of letters to the landlord has communicated that there's a serious issue here. The landlord is likely the one who's going to respond to this situation and go through their powers and process under the Residential Tenancy Act to potentially evict this tenant or give notice of serious violation. But if it ever gets to that point where the strata has to evict, this is a pretty powerful deterrent, actually, Hunter, as you put it. Just the very fact that the tenant understands that they could be evicted by the Strata Corporation is a pretty powerful message coming across to them, because they probably don't realize that. In fact, I don't think anybody realizes this yet because it's so new. And to be honest, it is so new, this process, that I haven't heard of a strata yet who has gone through this process to try to evict a tenant. I think it's probably going to take another year or so before we start hearing stories where this is being tried. But it is so new for the tenancy branch to recognize this, that I would say if a council ever gets to that point, don't try to do this yourself. You're going to need solid knowledge of not just the Strata Property Act, but the Residential Tenancy Act. You're going to need really solid documentation of all of that bylaw enforcement that you did, copies of every notice, copies of every letter, copies of council minutes, every single time you made a decision about fines or continuing contraventions or anything to do with getting to this point. So I think it's definitely something you'd want to reach out to a lawyer for advice to find out, you know, do we have enough documentation? Is this actually a significant bylaw? You know, is this actually interfering with someone's use of their strata lot? And before you go put everybody through that process of notice of eviction, etc., like, get some legal advice, because this is untested, and it could be a very, very stressful thing for a council to try to do if you don't have help.
Yeah, no, and I definitely agree with that. From my understanding of this, you know, the reality of this new, for the Residential Tenancy Act, kind of the section is more the acknowledgement that this is less of an issue with a tenant and more of an issue with a landlord that is taking action. Which that, you know, that test is a little bit higher, and sometimes more difficult to prove, certainly. So we'll certainly kind of echo the fact that if you're in that situation, get assistance from a professional, certainly.
But that's a good point, Hunter. Even just because most landlords won't know this yet either. Even just them understanding that the strata has the power to evict their tenant, that's going to be quite a shocker. And hopefully that shock shocks them into doing something about the situation that's led to this.
Yeah, definitely. I mean, and you know, I suppose the other part to it is to ensure that, you know, that landlords are aware that this can happen, but also that it's not a, oh, well, I can pass this off to the strata to do the work on this, because it's not an easy thing, and it's likely going to end up being more costly and time consuming for the landlord anyway. So you know, the Residential Tenancy Act allows for landlords to end tenancies in you know, those types of situations that likely would fall under this for stratas as well. So it would generally be easier. The bar is a little bit less high. I guess they have a, you know, a bit of an advantage when it comes to that because the act is written specifically for them. Um, we've talked about, you know, the kind of some of the rights that strata corporations have. In our last session we talked a bit about landlords. What rights do tenants have under the Strata Property Act?
Yeah, so speaking of shockers, this is one for a lot of strata owners and councils that they don't realize that tenants do have quite a few rights under the Strata Property Act. If you remember going back to the Form K, and it was the landlord's responsibility to give a copy of the bylaws and rules. So here's something for the landlords who are at today's session. If you didn't give that copy of the Form K to, if they didn't do the Form K at all, or if you didn't give a copy to the strata and your tenant finds out, they can actually end the tenancy with you without penalty within 90 days of that. And the landlord might have to pay the reasonable moving expenses as well. So basically, I think that means, you know, if you didn't give them a copy of the bylaws and rules and they have a pet and they find out that they're not allowed to have pets because you didn't tell them, then it gives the tenant a chance to go, well, hey, I don't want to live here. I have a pet, and it gives them an out. And so that, you know, the landlord might have to remedy that by giving them reasonable moving expenses. But that's really between the landlord and tenant, but it is a surprising part to have it in the Strata Property Act. But then the other things that a council would be more concerned about is, for example, a parking stall. If it's a common property parking stall, council is supposed to be assigning those to the owners who are requesting use of a parking stall. Same thing with a tenant. The tenant has the right to short-term exclusive use of things like a common property parking stall. They have to pay you, in that case, for example, there might be a rental fee for that parking stall, and the tenant would have to pay that user fee. Now, they might work that out with the landlord, right? It might be part of the tenancy agreement or whatever, but it might not be. It might not have been contemplated at the time of the tenancy agreement. And if the tenant has asked for something from the Strata Council and there's a fee for it, the tenant might have to pay that fee. So that's interesting. But other things, they're allowed to come to your annual general meeting. If you're using the standard bylaws, standard bylaw 26 says that tenants can attend an AGM. They can also participate in discussion if the chair allows them. And then there's this part in the standard bylaw that says anybody who's not eligible to vote, so that could be spouses who aren't on title, tenants, other guests, they have to leave the meeting if there's a majority vote of the people at the meeting saying, we don't want these people here, please leave. So there is that way, but a lot of people don't realize the tenant can attend.
I think that would be a rather awkward meeting to get voted out.
It happens.
I'm sure it does. Yeah. So I mean, those sound in many cases, it's going to sound, a fair bit of kind of standard kind of rights. Um, they don't seem, too far-reaching when they can attend an AGM, but they can't vote. So at the end of the day, that's, you know, that's important to have their voice heard, certainly as a person who lives in the building. But can their landlord give them any additional rights?
Yes, and this is a pretty serious decision for a landlord to do this. If they've assigned some or all of their duties to the tenant, there's a number of things that tenant can do. So a tenant could ask the Strata Corporation to give them copies of records. They could serve as a council member. They can vote at the AGM, which means that the landlord can't vote anymore. They have literally given away all their power. It's called an assignment of powers and duties under Section 147 of the Act, but they have to tell the council, right? And like, if you remember back to the owner's list, part of that owner's list is, have there been any assignments of these powers and duties from the landlord to the tenant? Because the council needs to know who gets the notice of the AGM, things like that. You're no longer, it's the tenant that you have to give it to, because they're the ones with the voting rights who are eligible to come to the AGM and vote. And if you don't have that on your list, you're not going to know who to give notice to. And when people sign into the AGM, you're not going to know who is allowed to sign in as a voter. So that's a pretty serious thing. But the other thing that, like, from the landlord's point of view, that they might not realize that they've given away the power to vote for their own strata lot. The other thing that's tricky about this is that they might have also downloaded the responsibility to the tenant to pay strata fees, to pay special levies, to make repairs to the strata lot. So although I've never been in that situation, I would think that the landlord and the tenant would need to seriously discuss this, possibly have a separate agreement, because you can imagine if a special levy came up and the tenant found out they were supposed to pay, that's pretty tricky. And you really, like, it's not really up to the council to have to try to get in the middle of a possible argument between a tenant and the landlord over who should pay. But I would just caution any landlord to be really careful before you do this. And once you've assigned that to the tenant, what if the tenant doesn't actually exercise those rights? What if they don't go to the AGM and vote? Then you've kind of got this situation where nobody can vote. And that's what happens in a long-term lease. So if your landlord enters into a long-term lease where the tenancy agreement actually says the term is 3 years or more, which most people, I don't know about you, but I wouldn't think that is as common. But if they did, this is the serious situation. Those powers and duties automatically go to the tenant. So the landlord has completely lost their powers and duties. The tenant has it, but then again, the tenant can't exercise it unless they inform the Strata Corporation. And I would say that a lot of tenants might not want to exercise it, because why would they want to pay the strata fees? Why would they want to pay the special levies? And so in this particular situation, it is very possible that nobody is able to vote at an AGM for that strata lot. So if the strata has not been notified of this, it's not a strata problem. As far as you know, your owner's list says that the owner is the owner. You're giving notice to the owner. They will have the one with the vote until you actually until council actually gets notified that someone has powers and duties. It's not your problem. You don't have to worry about it.
I think I tend to agree that, that definitely isn't something that I think people, one, are very aware of, but also maybe not the worst thing people aren't aware of, because the reality is most tenancies, if it's a fixed term tenancy, if there's that time frame assigned at the, set at the beginning, it's for 1 year. It's pretty rare for it to be more than that. And if it is, then generally the most it kind of gets to is maybe 18 months, maybe 24 months at the kind of furthest outset. Neither landlords or tenants necessarily want to be tied to that tenancy for much more than a year, 18 months. So yeah, I think that.
And I would say that neither of these situations, section 147 and 48 of the Act, the powers and duties, the entire section about powers and duties, you could live and be a council member for 30 years in your strata and never have this come up once. It's pretty rare, but just be aware that if you get a letter that says that notifying the corporation that somebody has given their powers and duties to somebody, just be aware that that's legal. Go read the Act, ask a lawyer, you know, whatever you need to do just to feel better that yes, the tenant has the right to be on council, has the right to vote. If you're not sure, just get legal advice. All I'm saying is this is very rare that this would come up in your work as a council member.
Okay. So I guess we'll get to our last question. We've talked about what the rights are of a tenant, both kind of just standard kind of passive rights, but also the rights that can be assigned, which of course come with additional duties as well. What are the tenant's obligations under the Strata Property Act?
Obvious ones, yes, they have to follow the bylaws and rules, and in particular, you know, those standard bylaw 3 ones about not causing a nuisance or noise or unreasonable interference. But there's a couple of things that the tenants in the building are probably not going to know. One is that if council asks a tenant for their name, they have to give it. So, you know, this happens a lot where, you know, the tenancy might start with one person and then someone is added to the tenancy and nobody notifies the council, and the council's like, well, we're seeing people who appear to be living here. Who's living here? Under standard bylaw 4, the Strata Corporation is allowed to ask for the name of the tenant. And the tenant won't know this. You know, that they might think that this is an invasion of their privacy or something. So I would say check your bylaws to see if that's something the Strata can do. And if you do it in writing. You know, like try to be formal about it because it is a part of the bylaws. But the big one for tenants is permission to enter the strata lot. If you're using standard bylaw 7, it says, you know, in an emergency, an authorized person of the strata can enter the strata lot. What does it say? Without notice to ensure safety or prevent significant loss or damage, right? So you got water coming, like pouring through the ceiling. And, you know, just know that an authorized person, someone authorized by the strata, can enter the strata lot. So that's typically going to be plumber, restoration company, something like that, right? The tenant's going to be freaked out. They're not going to know that this is something that they have to comply with. But the other thing is at a reasonable time's notice. So, you know, 48 hours written notice plus time for deemed notice. If the strata needs to inspect, repair, maintain common property, or portions of the strata lot that are the responsibility of the strata to repair and maintain or to insure, that notice is given to obviously owners and tenants, and the tenant has to let the person in. So that could be somebody who repairs and maintains, you know, baseboard heaters that are, you know, the hot water ones, the hydronic ones. That's part of the Strata Corporation system. But most typically it's the smoke alarm system, right? That once a year testing of all the fire safety equipment. The tenant has to let the technician in. It's in the bylaws. That's it. Those are the main ones I can think of. The obligations of the tenant that they might not be aware of. Oh, you're muted.
That's great. Yeah. So that is our kind of questions that Wendy and I kind of come up with over the last little bit to kind of kind of have a primer on this. I see that lots of questions have come in through the Q&A feature. Thank you for that. Continue to go ahead and send those in, and we're going to start getting through some of these questions right now. So just a really good one to start us off with. Which legislation takes precedence, the Strata Property Act or the Residential Tenancy Act?
Oh, well, both. I mean, it depends what you mean by precedence. There's not a heck of a lot that would conflict. So, what is the question? What is it that someone thinks is a conflict? And if you're not sure, ask a lawyer, because I would think that most of the time the conflict is a bylaw, not the Strata Property Act. And in that case, you might either have an unenforceable bylaw. It might not have been well contemplated. But again, when we're talking about rentals, you can't have much in the way of bylaws anyway now. So most of us have to have our bylaws reviewed and just cleaned up after last November. There's no rush to do it. You just can't enforce certain bylaws about rentals. But yeah, I'd have to know what is the detail that somebody thinks is conflicting in the two pieces of legislation.
And that's something maybe we can just highlight in general about this idea of pieces of legislation that take precedence over another. The general kind of hierarchy of legislation starts at the bottom with municipal and regional bylaws, and moves up from there to provincial legislation, and then of course the where the authority sits with federal legislation. So it's kind of the general order in which we look at kind of precedence, if we want to use that term, or I suppose legislative superiority. Um, and the Strata Property Act and the Residential Tenancy Act are both pieces of provincial legislation, so they're on the same level. And certainly, occasionally, different pieces of legislation are going to have policy tension around certain parts. I mean, a good example is before the Residential Tenancy Act changed, you couldn't evict a tenant through by a strata council under the Residential Tenancy Act, but the Strata Property Act allowed it. So a situation where there was a bit of kind of tension there, but certainly it wasn't so much that one superseded the other or was more superior than the other, just that they didn't work all that well together. And so oftentimes when legislation doesn't work all that well together, it just means nothing happens. So next question is around restrictions in rentals. I know you've said that there really can't be restrictions, but I do wonder about this one. Can a strata property or strata corporation restrict the number of tenants per unit?
Well, it can restrict the number of occupants for any unit. So you're not restricting the number of tenants, you're restricting the number of occupants. So for example, I've seen many stratas where it's something like the maximum number of occupants in a 1-bedroom is 3 people. The maximum number in a 2-bedroom is 4. The maximum number of occupants in a 3-bedroom is 6. That is applying to everybody. That's allowed. It's not allowed to say this only applies to strata lots that are rented. That's not allowed. It has to, and it's a pretty simple test to ask you, is this being fair between owners and tenants? If it applies to everyone and it's a bylaw that doesn't contravene the Strata Property Act or some other piece of legislation, then it is possibly a good bylaw that can be enforced. But if it, or I always say, if it quacks like a duck, if you're trying to find some way in your bylaws to restrict or discourage rentals, then get some legal advice, because you might be actually doing something that is not in compliance with the law.
Can a strata have condo fees that are based on the number of occupants, the number of people that are living in the unit, regardless of landlord, their owner or tenant?
No, the only legal way that the Strata Property Act gives us to figure out our strata fees is based on unit entitlement. A unit could be empty. A unit could have 10 people living. It doesn't matter. The Strata Property Act is very specific about how strata fees are calculated. And the only way to calculate, come up with a basis for calculation that's used for strata fees and special levies that's different would require a unanimous vote of all the owners. And that's not just people who show up at the general meeting. That's every single owner on title in the strata corporation. So for most of us, unless you're a really small strata of 3 or 4 units, it's essentially impossible to get a unanimous vote to change the basis of calculation. So yeah, don't go there. Just your schedule of unit entitlement is filed at the land title office. That is the only schedule that you're allowed to use. So if you haven't pulled it from the land title office in the last few years, get a copy. Because I know we got some information. I think it's 38% of stratas are calculating their fees wrong because they're using the wrong schedule of unit entitlement. So it's good to check.
That is not a small amount to be calculating something wrong, for especially something that's, you know, I've seen how high those strata fees can be. They're not insignificant.
They're usually not out by much.
Yeah,
but you know, $5 a month here or there over the course of years,
adds
it
up.
adds up.
It certainly does. When a tenant has left and they owe money on a discretionary item, that's something that's not included within the agreement itself, such as laundry, when in this situation it's billed every 2 months. Who is responsible for the unpaid item? Is it the tenant or the landlord?
If this is from the strata corporation's point of view, they're charging the strata lot. And then if the landlord has made an agreement between them and the tenant that the tenant's supposed to pay, then that's between them. Basically, if it comes down, you only have 2 years to collect monies owed on strata fees and etc. So there's a process in the act to send a demand for payment letter. I think it's section 112. That's a whole process. But basically, the strata corporation's relationship is with the owner of the strata lot. Ultimately, like if this was fines, for example, you can't lien for fines. But if this was fines, even though you fine the tenant, ultimately under the act, the strata owner is responsible to pay them if the tenant doesn't. So although I don't know all the details here, I would say that, you know, you're trying to collect from the owner of the strata lot. And I'll just say if it's a significant amount of money, you might want to get some legal advice, because you don't want to let it go and balloon and get to be this big amount. But I would say in most cases, you're trying to collect from the owner.
Yeah. And this is something that comes up in residential tenancies as well. Things such as, say, water bills with municipalities. The reality is that a water bill, you can assign it to your tenant, but at the end of the day, if the tenant doesn't pay, it goes to the property, and they collect from the property. Now, that doesn't stop an owner from going and trying to collect from their tenant. And we're not going to get into the lengthy conversation about trying to collect from a tenant. If anyone on this webinar has done that, it is not a simple task by any means. But it is, if we're looking at kind of just this topic from whose responsibility things are, generally, you know, ultimately the owner is responsible for the property. And it seems that that's similar in stratas. At the end of the day, it goes back to the lot itself, and that, you know, the owner is the one who has that long-term responsibility for it. What defines a short-term rental for stratas?
Oh, right. So this is a big question these days. Everybody's looking at the Short-Term Rental Accommodations Act that just got passed at the end of October. And one thing I'll say is that it's not an easy definition. So prior to this, The definition really was, what did your municipal bylaws say? And in some municipalities, they didn't have any bylaws about short-term rental accommodations. And in some, they said things like anything under 30 days or something like that. Now, the new Short-Term Rental Accommodation Act by the province has a definition of less than 90 days. But I want to caution people, the definition of short-term accommodation is not really the number of days. It is, what is the contractual arrangement between the two people? And here I'm going to use an example. If you're truly using a strata lot for short-term accommodations, it is that vacation, temporary accommodation, legal arrangement. So imagine this, it's like renting a hotel room. There's no what they call right of possession. That cleaner can come and knock on the door and come in and clean the room at any time. If there's a problem in that hotel room, the manager of the hotel can come into that room at any time. But if it's a tenancy, there's a whole process of giving notice before entering a rental unit. So there's it really comes down to what is the contract, what is the agreement that is allowing this person to stay in the unit. It's a completely different type of law. So I try to get people not to think too much about the definition. Go to your lawyer, go to your strata lawyer, and they will write a very long bylaw about banning or limiting short-term accommodations, because it's complex, and it's not just the law, it's case law. And we have some excellent case law in the strata world since about 2018. And here's the thing, you can have two bylaws that look the same with two words that are different. And the Supreme Court had said, yes, you can uphold this. This bylaw stands up. It really does mean short-term accommodations aren't permitted. And I'm not kidding, a couple words different, and this bylaw is found to be vague, confusing, or contradictory, or whatever, and it's thrown out as being unenforceable. So you can't write these yourself. You need a lawyer, and you need a lawyer who's familiar with recent case law. This is definitely not something that council should try to write themselves. It's a waste of time if you have a bylaw that's not enforceable.
Yeah. I'd like to just add to that, you talk about how, the contract is part of it, and it is. This is something that comes up in rental units all the time. Is kind of trying to determine, is something a vacation rental or not? And, it's nice to see that we have a bit of a definition, I suppose, in this new legislation, but it's not a great definition by any means. I'm sure that they struggled quite a bit when writing this, saying, how do we write this thing? What constitutes this? And even with that contract in place, there are situations that can arise that can really change that. And we have seen situations where someone has been in a hotel, and if they have been able to establish that despite the agreement being arranged originally under, the Hotel and Innkeepers Act, for example, and it really appearing as it started as that kind of short-term temporary vacation or travel accommodation, over time became a rental under the Residential Tenancy Act, and it was in a situation where it was a building called a hotel, and it actually had I'm not going to go name the specific hotel chain that it was, but it was actually a chain of hotels. And the tenants successfully said, all of the tenants in the building actually said, well, we've all lived here for 6 months, a year, 2 years, 3 years. The ownership knows that we're living here and that this is our home. So this is a tenancy. So that contract was thrown out, and they were all covered under the Residential Tenancy Act. So that it is such a complicated and kind of mercurial thing. It changes from moment to moment depending on who's interpreting it, the exact situation, the 2 or 3 words in a bylaw. Those are all things that really, really can change it. So getting legal advice in those cases is vital.
One of the things I like about the Residential Tenancy Branch website touches on what you just said, Hunter, but I like when they describe by using the word permanency.
Mm-hmm.
Is someone living in this strata lot as a home? And even, and it's difficult, to for a council to know, but I mean, if I've taken all of my clothes, all of my books, and possessions, I'm not talking furniture, but just, my
Yeah.
stuff. And I've, moved into a room for a month. That could be my home, is my permanent home for,
Yeah.
even though it's a short amount of time. But if I'm just taking my suitcase and all of my stuff is at my other place that is really my home, then that's a transient accommodation, temporary accommodation situation. So, but you're right. We could talk about this one all day. I suppose I should just leave it and you can help us get
No,
to the
no,
next question.
I agree. It is a complicated topic for sure. Um, is a strata within its right to require a minimum length of rental to be at least 1 year, or is there any minimum that can be put in there?
No, that's considered a restriction. So basically you'd be saying to other owners, you can't rent for 8, 9, 10 months because we've made this requirement that you have to be there for a year. That is considered a restriction, and section 140 of the 141 of the Strata Property Act says you can't restrict a rental, and that is period. There's no gray area there for you to make a bylaw that makes exceptions. So, a true tenancy could be very short. It could be 30 days, 60 days, whatever. It depends. So I would just say, talk to your lawyer, because you probably just want to scratch that bylaw, or at least not enforce it while it's in your bylaws.
Should the tenancy agreement itself between landlord and tenant be shared with council? Can they have a copy of that? Can they request a copy of it?
We've had a couple of lawyers weigh in on this one. And basically what they've said is you could try to have a bylaw that requires a copy of it, but they caution why. Your Form K says who the tenant is, and it's been signed. You know who the landlord is, you know which strata lot isn't. What exactly is the purpose of getting a copy of a tenancy agreement? It's none of your business how much that person pays in rent. It's none of your business who pays the utilities. It's none of your business if they've put in terms. Like I said, in the Strata Property Act, the Strata Corporation can't require the insertion of terms. So why do you want a copy of that tenancy agreement? It is definitely something to consider with the Personal Information Protection Act. As strata corporations, we're only allowed to collect personal information for a purpose, and only the least amount of information for that purpose. So I would ask yourself, what is the purpose?
Yeah.
Because there is probably no reason for you to ask for that information. But if you insist on having a bylaw that requires the landlord to give you a copy of the tenancy agreement, run that by your lawyer, because it is so crossing the line. Yeah, I wouldn't personally think it was necessary.
Yeah, and that's, I mean, I think that's the heart of any interpretation of the Personal Information Protection Act. The same with tenant selection and residential tenancies. You can gather a lot of information, and it is a lot of very sensitive information. But at the end of the day, you will have to have a reason for collecting it, and that reason can't just be curiosity, um, as tempting as that might be. So that just kind of is hard, I think, and the kind of the spirit of that legislation. Um, I'm going to really quickly answer this question because it just kind of popped up. Isn't anything under 6 months not covered by the Residential Tenancy Act? That isn't true. The Residential Tenancy Act can apply to a tenancy pretty much of any length, unless we're classifying it as travel or vacation accommodation. So that's, and again, the definition of that is, as we've just kind of said, kind of very situational. Intent is part of it. The contract is part of it. How you advertised it, the kind of makeup of the property. There's so many little things that affect that. So the act does apply to tenancies that you could have a tenancy that's 3 months. Have one that's 2 months if you really want it.
Yeah, so let's acknowledge here, Strata Council can't know in many of these situations. How are you supposed to know whether it's a true tenancy or whether it's a short-term accommodation? Remember that enforcing bylaws is a process. A complaint has to come in. Once you receive the complaint, you might try to investigate. Investigation might be something like going on Airbnb's website and seeing, our units being advertised. Do you actually have a bylaw that is enforceable against short-term accommodations? I mean, this is where I think these questions are leading.
Mhm.
It's about banning short-term accommodations. And don't forget, with this new legislation, the Short-Term Rental Accommodations Act, a lot of what we're seeing in strata corporations that are problems with short-term accommodations could resolve themselves within the next year, because that act is placing very strict restrictions on who is allowed in the entire province to do short-term accommodations. So you may want to just see how the dust settles in the next year before you write any new bylaws banning short-term accommodations. And definitely, this is where you reach out to your lawyer. If you're not sure if you can enforce a bylaw like a short-term accommodation bylaw, there's nothing wrong with getting a little bit of legal advice and taking away the stress off everyone's shoulders by making sure that you're not doing something wrong.
Yeah. I mean, it's easy to say that we want to save money and not spend that type of money on a lawyer, and they're not inexpensive, certainly. But I can say from witnessing it many times, the 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 financial cost, the headaches in time and effort and frustration that come from making a mistake on that, doing something improperly, um, far outweigh the due diligence of getting that advice up front. Um, I think we're going to just go to one final question. Um, Someone has asked about where they can get resources on this topic in general. Is there a government agency that covers this? Is there a the association? I'm not
You mean
leading
the
there in any way.
topic of short-term accommodations, or topic of?
Would someone suggest someone to go to for assistance in Strata Council was going to attempt to specifically, we're talking about evicting a tenant in this case, but is there a government or social body in place giving out this kind of information? Any lawyers that would be, within that realm?
Well, if Strata Council is looking at evicting a tenant, the first thing I would say is read your bylaws. You can come to VISOA for a little bit. We can point you to, here's the parts of the act you should read. We can point you to that information, but ultimately you're in the same place. You need someone who thoroughly understands the Strata Property Act, the Residential Tenancy Act, your bylaws, the process that you went through for the bylaw enforcement process, whether or not that alleged breaking of bylaws was significant enough for the strata to have a basis to evict. I mean, there's so much here that you can't do as a regular person. You just can't. So at some point you're going to need legal help. We have a list of strata lawyers on the VISOA website, but you can also just Google Strata Lawyer BC and you'll find lots of them. Yeah.
Fantastic. Yeah, and LandlordBC, we have several different law firms that we work with that our members have access to. Find that directory on our website as well. So I'd like we'll bring this to a close. Is there anything you'd like to kind of recap, Wendy?
Just that LandlordBC and VISOA are here. We are supports for our members. So if your question is more on the Strata Property Act, Strata bylaws side of things, our website is visoa.bc.ca. LandlordBC would be more for those owners of strata lots who are landlords. And Hunter, your website, I don't want to say it wrong.
LandlordBC.ca.
You know, both of our organizations are about education support and advocacy. So, you know, that's what we're here for. And although neither organization gives legal advice per se, we can often give information that helps you prepare and save money before you get to the point where you need to call a lawyer.
Yeah. Here at LandlordBC, we have a fairly well-staffed legislative helpline that provides operational advice, and when things do get to that more serious thing, situations, then we can refer to legal advice as well. I'd like to encourage everyone to join us on January 20th for our next session. It is a landlord's guide to communicating with strata councils. So in that one, Wendy will be asking questions of myself. We're going to be having a conversation much like we have today, just a bit the other way around. So again, thank you all for your attention today, your very thoughtful questions, and look forward to seeing all of you at our next session on January 20th.
Thanks, Hunter.
Thank you.